The United States Constitution, a wonderful document that secures life, liberty for American citizens. How this document has worked over the last 200 years, however, is depending on what the courts do. We are secure in our homes from unreasonable search and seizure. What that means is you're never going to have the secret police showing up at midnight, knocking at your door, demanding to come in and searching through your possessions for evidence that they can use to put you in jail. Now, the way in which that is prevented, however, is on a case-by-case basis and on courts interpreting the Constitution. In this instance, most importantly, the Fourth Amendment, which prohibits unreasonable searches and seizures. And that takes us to this week's case. It involves someone who was a kind neighbor. She happened to see a suspicious person, or whom she thought was a suspicious person, climbing over a neighbor's fence. She called the police. The police showed up. They happened to see the fella over the fence. They immediately went to the backyard, kicked in the door of the fence, the gate of the fence, went in, apprehended him, and arrested him for suspicious conduct because there was no reason they found for him to be there. Well, lo and behold, it turns out the fellow that they were arresting lived on that property. It was his home. Unfortunately for him, it turned out he was a prior felon, and in his backpack was found a pistol. He, because he is a prior felon, was prevented from carrying a pistol. He was therefore prosecuted for unlawfully having a weapon. All right, the case goes to court, goes to U.S. Federal District Court. There, the Federal District Court found that the search was reasonable, found that there was probable cause for the police to come into the backyard and seize the man. Went up on appeal to the Ninth Circuit Court of Appeals, and up there the court took a little different view. They said, you know, in this instance the police were advised that this appeared to be a suspicious character by a neighbor who obviously didn't recognize that this was her neighbor that was coming over his back fence. We don't quite know why. And when the police showed up, they did not use reasonable means to determine who this guy was. They didn't try and alert the homeowner. They didn't knock on the door. They didn't even ask the fellow, hey, what's your name and why are you here? They just immediately apprehended him, detained him, and then subsequently arrested him after they had searched him. Court said, no, that is unreasonable. Unreasonable. It's unreasonable because there were other things that were going to be less invasive that the police could have done. Because the police chose not to do it, it therefore was an unreasonable search and seizure, and the evidence, the gun that he shouldn't have had, was thrown out. It couldn't be considered in any prosecution. Okay, so we see how this works, how the Fourth Amendment works on a case-by-case basis. Now, a lot of people will say, well, why is the evidence thrown out? Why can't we do something else? I mean, the evidence was found. He certainly shouldn't have had the gun. Why was the evidence thrown out? Well, in our approach to dealing with unlawful activities by the police, we find in the United States that if the evidence was not properly obtained pursuant to case law, pursuant to the way the Fourth Amendment is interpreted, then the evidence is thrown out. How else are we going to make sure the Constitution works? We could find the police officers, and in some countries that's what's done, but here we've said, no, we're not going to do that because here we want to see if there's a question, if there's a tie, it's going to go to the citizen, because the Constitution is all about keeping government out of your backyard. Okay, we bring you this case this week as we bring you cases every week so you understand how the law works. I'm David Allen.